Um, Good day. The Limbas Mandaragit Eagles Club of the Fraternal Order of Eagles, Philippine Eagles, is here again to serve you. Well, our topic really is that should the person arrested without warrant be charged in court? Ididemanda ba? Sampan ba ng kaso sa hukuman ang taong inaresto ng police officers or barangay tanod without a warrant of arrest? Okay, this is the rule. The person arrested without warrant shall be immediately delivered to the nearest police station or jail. Sinong nagsasabi? Rules of court. Hindi yung iikot-ikot pa. Halimbawa, the person was arrested in Quezon City. Ba hindi pwedeng iikot-ikot muna, nakarating ng Caloocan City, andun sa Tondo, Manila, nakarating na ng Las Piñas, bago dadalhin sa kulungan. No! The person arrested without warrant, according to the rules of court, shall be immediately delivered to the nearest police station or jail. And not only that, meron ding requirement. Anong requirement? Tika muna, dinala mo na sa kulungan yan. Well, under the rules of court, of course, under the revised penal code, the person arrested should be brought to the judicial authorities within 12, 18, or 36 hours from arrest. That is, pag sinabing to be brought to the judicial authorities, ibig sabihin, he should be charged in court. Iba paano kung hindi na-demanda within 12, 18, or 36 hours? Anong epekto? Should there be failure to file a case, a criminal case in court, within 12, 18, or 36 hours, nako, delikado. Why? Because the detaining officer or officers may be held criminally liable for delay in the delivery of detained individuals to the judicial authorities or for arbitrary detention. Kailangan masampahan nila yan. But you will note that in this kind of cases, arrest without warrant, the person arrested should undergo an inquest proceeding so that he can be charged in court. So, for this purpose, the person arrested should be brought to whom? To the office of the prosecutor for inquest. Inquest ang tawag dito. Inquest. Now, the inquest proceeding, or in the inquest proceeding, the prosecutor will study the case. Pag-aralan niya yan. But nakafocus agad dito ang prosecutor on the affidavit of arrest. He will study the affidavit of arrest executed by the arresting officers. Anong titingnan niya? Titingnan if the warrantless arrest is lawful. Okay? Should the prosecutor finds that the warrantless arrest is unlawful, then the inquest prosecutor will issue a release order for the immediate release of the person arrested from custody. So, meron ng pupuntang office staff ng prosecutor. Saan pupunta? Doon sa police station or jail where the person arrested was detained. Pupuntahan or is detained. Pupuntahan siya doon. Madala-dala na yung papel, ando na yung release order. So, tuwa ngayon yung person arrested. Goodbye kakosa. Lalabas na siya. Okay? But should the prosecutor finds that the warrantless arrest is lawful, then he will study the merit of the case. The prosecutor, in studying the merit of the case, shall base his findings only on the evidence submitted by the complainant. Paano yung nakulong? Wala siyang ebidensya. Wala. Pagsabi, unfair naman, ba't ganun? Talagang ganun mangyari, unfair. Why only the evidence submitted by the complainant? Because the proceeding is only an inquest proceeding. In an inquest proceeding, yung taong nakakulong, the person detained or arrested, he will not be allowed to submit his defense evidence or his counter affidavit. Why? Because under our rules and existing jurisprudence, an inquest proceeding is only an informal and summary investigation, conducted by the prosecutor in criminal cases involving persons arrested and detained without what? Without a warrant of arrest. Now, what is the purpose of the inquest proceeding? Well, for the purpose of determining whether or not this person arrested should remain under custody and thus should be correspondingly charged in court. Now, should an information or should a criminal case be filed in court by the prosecutor, well, the accused may avail of his right to a preliminary investigation. How? By filing a motion for preliminary investigation. Now, if it is granted, then good for the accused. Accused na siya ngayon. So the investigation shall be referred back by the court to the office of the prosecutor. In the said preliminary investigation, the accused shall be given the opportunity to submit his counter affidavit. And not only his counter affidavit, but the affidavit of his witnesses. Well, it is the prosecutor who will conduct the preliminary investigation. Pero mahigpit dito ang batas, yung revised guidelines for continuous trial for criminal cases. Why? The motion for preliminary investigation should be filed within 5 days from the time the accused learns that a case has already been filed against him in court. Mandatory yan. Now, in the preliminary investigation, as ordered by the court, should the prosecutor still finds probable cause against the accused, then the case shall be set for arraignment and pre-trial. Yung arraignment, doon yung babasahan na siya. Oy, ginawa mo ba ito o hindi? Sabihin ng akusado, hindi, not guilty. Now, at the arraignment, should the accused appears in court without counsel, naku, walang abogado, the judge will inform him of his right to have a counsel. And the judge, in fact, may even appoint a counsel de officio to defend the accused. Usually, ang ina-appoint dito, a lawyer from the public attorney's office. Of course, private lawyers can also be appointed as counsel de officio. Right? Well, this is another public service from the Limbas Mandaragit Eagles Club of Antipolo City, Lalawigan ng Rizal. Maraming salamat.